Hello. I see our participants and registrants are joining us. We want to welcome you as you join this Zoom to the Senior Statesman of Virginia's April program on the Virginia Constitution and who has political ownership and participation through the Virginia Constitution. So again, we're glad that you're able to join us and happy that we can still provide the program via Zoom, so it's convenient to everyone. And as you may or may not know, the program is being recorded. So if you would like to view it again, or you have friends or family who couldn't join, but you would like for them to also enjoy and learn from the program, it will be available on the Senior Statesman of Virginia website by end of day tomorrow. So again, welcome to this program. I'm Sue Friedman. I have the true honor of being president of the board of directors for Senior Statesman for 2022. And today we have one of our board members, Bob Beard, as our moderator. So I'm going to introduce Bob Beard and let him bring this program to you. Thank you, Bob.
All right, thank you very much, Sue. We are pleased to be joined today by A.E. Dick Howard. He is the Warner Booker Distinguished Professor of International Law at UVA, graduate of University of Richmond, law degree from UVA, Rhodes Scholar at Oxford. He was executive director of the commission that wrote Virginia's current constitution and directed the successful referendum campaign for its ratification. The latest constitution became effective back in 1971. But how well has it stood the test of time, and what are the challenges of our era? Professor Howard, thank you again for taking the time to talk with us today, and the floor is yours, sir.
Bob, thank you very much. I'm delighted to be with you and Sue and those who are watching over Zoom today. And as Bob mentioned, it's now been 50 years since the present Constitution of Virginia took effect, July the 1st, 1971. And I think to understand why that Constitution came into being, what it was all about, what it means, what we should be thinking about it today, I think it requires a little bit of Virginia history of where it all started, how it evolved. And there's so much one could talk about. I want to take as my theme, if I were a preacher, I would have a text from the good book. But what I want to do is to take a line from George Mason's Declaration of Rights of 1776. That was the world famous document which really launched this whole enterprise, and it's still part of Virginia's Constitution with a few little changes as Article 1, the Bill of Rights. And when you read the Declaration of Rights, you find a very capacious, inclusive definition of what the community is all about. Who are the people who can look to that Bill of Rights for protection? It says that government is instituted for the common benefit, protection, and security of the people, nation, or community. So that's a very broad definition. But as you then read down through the successive sections of that Declaration of Rights, then you get to the proposition on who actually gets to vote, who has the franchise, not simply who's protected by the Constitution, but who has a say in it, who has some ownership in that document. And the Constitution, the Declaration of Rights, says that to vote, men were voting those days. Of course, women were not yet admitted to the franchise. So it said that men have to have sufficient evidence of permanent common interest with and attachment to the community. Now, that doesn't define exactly who those voters are, but in those days, as you might suppose, it meant those who owned property. I mean, they were the people who had that attachment to and interest in the community. It was property owners. So that began a process of over 200 years of distillation and debate and redefinition of who is it that has the sort of interest in the community that they ought to be seen fit to exercise the franchise. Well, from the very first, there was a debate over whether this property qualification ought to be retained or not. Thomas Jefferson was one of the critics of that first Constitution. He complained about a number of problems with it, but in particular, he thought that the franchise was too restricted. He thought that more people, for example, those who had fought in the Revolution, they might not own property, but they certainly ought to be among the voters. Well, change was very slow coming about. Year after year, petitions were filed in the General Assembly at Richmond asking for a constitutional convention to rewrite that first Constitution. These petitions were heard, especially from this part of Virginia, from the Piedmont and from the Valley and beyond, because the old Constitution clearly favored people who lived in the Tidewater, the oldest part of Virginia. The small Tidewater counties, actually the ones who ran the show, and the growing, more prosperous Piedmont and Transmontane and Valley people wanted more say in things in Virginia. Well, finally, after about 50 years, a convention was held in 1829 and 30. Quite a remarkable body. It had President James Monroe, James Madison, John Marshall, a number of governors, senators, all the leading Virginians were there, and they debated this question of the franchise. Well, the changes they brought about were modest. They admitted free people who were leaseholders, if you had a house in town or that sort of thing. There was a modest enlargement of the franchise, and also some readjustment of electoral districts, but the changes were not profound. It was not until 1850 and 51 that another convention was held, and at that point, finally, the property qualification was dropped, and the franchise was extended essentially to white male suffrage. Again, of course, women were not yet admitted to the franchise, and of course, blacks didn't count. Most blacks were enslaved, and even free blacks were not in among the voters. But in 1851, the Constitution became more truly democratic. And you might be amused to know that it was not until 1851 that the governor was elected by the people. Up until that time, for the first 75 years, he was elected by the legislature. It was almost like a parliamentary system. So finally, in 1851, they trusted the people enough to elect the governor. Well, that, of course, was on the threshold of civil war. And things, of course, from that point, there was disruption and constitutional upheaval. Virginia was among the seceding states, 1861, and was part of the Confederate States until finally at Appomattox, that which was debated constitutionally was finally settled by the sword, and the Union was preserved. As you may know, in the Reconstruction period, after 1865, the states that had attempted secession, the states that were part of the Confederacy, in order to be readmitted to the Union, they had to do two things. They had to ratify the 14th Amendment, and they had to write a new state constitution which guaranteed the franchise to former slaves. Well, in Virginia, that convention was held in Richmond in 1867 and 68. There were just over 100 members of that convention, excuse me, just over 100 members, and about 25, roughly a quarter of those convention members were Black. Some were former slaves, some had been freedmen, but of course that was the first time in Virginia's history that the Black population, the African Americans, had had any say in writing the Constitution. Well, they produced a Constitution. It became effective in 1870, a very progressive document. It created Virginia's first statewide public education system. I mean, it was not very well funded, and it got off fairly slowly, but at least it was a beginning. There was a statewide system. Of course, now African Americans had the franchise, guaranteed by the 14th and 15th Amendments to the federal Constitution. That was the state of things for a few years after the Civil War, during the so-called Reconstruction period. But in 1876, there was a disputed federal presidential election. That sounds sort of familiar to us today, doesn't it? So there was a kind of a deadlock on which candidate would in fact be installed in office. And when they finally worked out a compromise, part of the deal was to withdraw the last federal troops from the South. Last ones left Louisiana in 1877. So that was the end of Reconstruction. And it didn't take very long before conservative white Southerners, people who liked the way things had been before 1861, tried to roll the clock back. They began to pass restrictive laws, so-called black laws, that made it difficult for agricultural laborers to move from one place to another. They used various devices to try to, they couldn't reinstitute slavery. Obviously, the federal Constitution stood in the way of that. 13th Amendment forbade that. But the so-called Bourbon Democrats, I'm picking up the name from the Bourbon monarchs of France, but the so-called Bourbon Democrats tried to reinstitute the old order as best they could. And one thing they had their eye set on was the 1870 Constitution. They resented that as having been imposed, they argued, at the point of a bayonet under federal initiatives. And so a convention was held in Richmond in 1901, 1902, and it was one of a series of conventions held throughout the southern states, starting in Mississippi in 1890, and one state after another revised and repealed their old Reconstruction era Constitution and put into place a more conservative post-Reconstruction Constitution. Well, if you ever read the debates of that 1901, 1902 Constitution, you won't be surprised by what you find, but I think even knowing what we do about Southern history, it's still pretty shocking stuff. I mean, one delegate, for example, in the debate said he wanted plainly understood that he was a white man and he was there to represent white interest. That's why his constituents had sent him there. And another delegate argued that what the purpose of this convention was to secure white supremacy in every city and county in Virginia. And he said the Anglo-Saxons claimed the right of government. So they wanted to disenfranchise blacks insofar as they could to completely eliminate the black population from state politics. Indeed, some delegates, I think, verged on suggesting that they not only wanted to disenfranchise blacks, but they were not too keen on lesser classes of whites voting, that they thought the better sort of people, the good sort of folks like themselves, really ought to be in charge of government. So they wanted blacks off the ballot. Well, what place would the African-American population have? And in the debates, delegates said, well, they do have a place. They belong on the land, in the tobacco barns and in the cotton fields, and that's what they are intended for, and they should not aspire to anything better. Indeed, at moments in those debates, you find some nostalgia for slavery. I mean, they couldn't restore slavery, but they did say, well, our black friends were better off when they were on the plantation, that the masters took good care of them and there was a good relationship. And those were in effect the good old days. The delegates at that convention invoked history as supporting white supremacy. They said in the thousands of years of civilized history, what has the African-American contribution been? They simply said that there had not been one. And they invoked theology. Some delegates argued that it was God's plan, that God intended for the white race to be the ones who would run things and the black race to be inferior. So does that mean you would educate black citizens or not? Some delegates argued that education was wasted on blacks. If you teach an African-American child to read, he's not going to read good things like the Bible or something of that sort. He's going to read things like Uncle Tom's Cabin or something which would give him pretentious ideas. So, and in particular, there was no place for blacks in higher education. It was just unimaginable to these delegates that a black person could aspire to be a lawyer or a doctor. That was obviously reserved for white people. So, I mean, I could quote you any number of passages in the debates. They would become cumulative and perhaps redundant, but everybody knew what they were about. I mean, today, if you had a debate like that, people would sort of sidestep and be maybe evasive. They wouldn't speak directly to what they were about. They would cloak it in pretty language. But these debates in 1901, 1902, they left no mistake what they were up to. So there were a number of devices which were being used by the other southern states and eventually by Virginia, like the poll tax, difficult registration requirements, so-called grandfather clauses, that if your father had fought for the Confederacy, you automatically were enrolled. You didn't have to go through any other registration requirements. Well, what about I mean, I'm describing a scene. If something like that went on today, you'd say, well, somebody would take it to court, and the U.S. Supreme Court would surely not countenance this kind of thing. Well, so as it turned out, the Supreme Court back in those days did hear a challenge to the Mississippi Constitution, which was very similar to the one finally written in Virginia, and they rejected the challenge. They upheld the Mississippi Constitution on the argument that on its face, it was neutral. It didn't on its face discriminate against people of color. And if it did in its application or administration, that was something else. Well, of course, everybody knew how it was going to be administered. So the Supreme Court in the Mississippi case had, in effect, given a green light to these delegates in Richmond. They knew they were safe enough. They did say they wanted to proceed within the bounds of the federal Constitution, but the Supreme Court had already said that that was no significant barrier. To give you an example of the kind of barriers that the convention in 1901, 1902 put into place, were registration requirements. You went to register, and the registrar could take out the Virginia Constitution and open it to any page at random and ask you to read and interpret some provision. There are provisions in the Virginia Constitution that I'm not sure I can interpret. And I'm sure if I were the typical African-American working man in 1902, that I wouldn't pass that test. Indeed, the whole point was, no matter how educated or erudite you were, if your face was the wrong color, the registrar was going to say, sorry, you failed. And so the result was that, I mean, if you knew you were going to be turned away, the black working man of 1902 is not going to lose a day's pay to go in and do something which is a hopeless effort. So the result was absolutely decimating the voting rolls. The number of black voters in 1870 had been close to 50% of those voters. And after the 1902 Constitution went into effect, it fell below 5%. So you can see there were not very many black voters left after that Constitution went into place. So the question this presents, I've given you that history, very brief accounts, because that brings us up to the present Constitution, the one that became effective in 1971. And I think the central question that this history poses is, actually I gave that title to this talk, namely, who belongs? Who is it that counts? Who are the people that matter? I mean, who are entitled to be part of the political community? Now, in 1902, not only did the drafters of that Constitution make clear who they thought ought not to have the ballot, they also had other ways of making clear who was on the inside and who was on the outside. For example, the Constitution of 1902 decreed that public schools would be segregated by race, made it clear that the two races were not to be put together. Well, after 1902, if you know some Virginia history, during the first half or so of the 20th century, the so-called bird machine was in control of things. This was a fair, as machines go, it was genteel. It didn't have to go around beating up people, but it ran the state very efficiently for decade after decade, partly because of the limited franchise. Virginia actually had the lowest percentage of its population enrolled at the ballot of any state in the country. We were at the bottom, even below Mississippi was low, but we were further down. And the Byrd machine from the governor's office ran things through the state compensation board and through the courthouse constitutional officers like the sheriff and the commissioner of revenue and Commonwealth's attorney and so forth. And as I said, it was a very efficient operation. Well, that began to fall apart in the 1950s with Brown versus Board of Education, and in particular in the 1960s. Now, those of you who are old enough to remember the 1960s, I think will remember a very turbulent decade. It was a time that the Vietnam protests were beginning to rise. It was a decade during which you saw assassinations of John F. Kennedy, of Martin Luther King, of Robert F. Kennedy. You saw cities in flame, arson and looting and rioting in a number of major cities. So you saw social upheaval, more to the point for our purpose of talking about the Virginia Constitution. You saw important legislative and judicial changes coming out of the federal government, out of Washington. The U.S. Supreme Court decreed one person, one vote, and that redrew the political map of every state in the country, including Virginia. Congress passed the Voting Rights Act of 1965, which of course applied to Virginia, as it did to other southern states. You saw the Supreme Court striking down, invalidating the poll tax. So there were a number of changes, and they were essentially revolutionary changes in terms of the legal landscape. Well, it was about that time that Governor Mills Godwin in 1968 asked the General Assembly for authority to appoint a Commission on Constitutional Revision. They gave him that power. He then appointed a very remarkable commission. It had the leading statesman of its day, Lewis Powell, who later sat on the U.S. Supreme Court, Hardy Dillard, later sat on the World Court at The Hague, Oliver Hill, who was the leading civil rights attorney in Virginia. He was the Thurgood Marshall of that time in Virginia. It had Colgate Darden, former governor, former UVA president, and so forth. I mean, truly remarkable group of commissioners. They in turn needed an executive director. They came to me and asked me if I would take on the job of essentially being the chief draftsman, the kind of guy who puts the parts together and helps get it on paper. I have to confess to you that when I just started teaching at UVA and just was a fresh-faced member of the law faculty, and I didn't tell them at the time, but I hadn't read the old Virginia Constitution. I mean, I was aware of it. I had reason to consult it occasionally, but I'd never read the document. I didn't know all the things that were in there. And it was, as you know, an appalling document. But anyway, I took on the job, helped them. Then the commission made its proposals to the General Assembly. They made some further revisions. The proposed Constitution then went on the ballot in November 1970. By then, Governor Holton had taken over from Governor Godwin. And Holton asked me if I would direct the referendum campaign, which I didn't know anything about politics, but I was happy to do that, and went around the state making talks and setting up campaign committees and doing all the things you do if you're a candidate running for office. We must have done something right because we got 72% of the vote when the time came. I think if you were running for office, you'd be pretty happy with that. So we got over 2 out of every 3 votes cast, even though there were some conspiracy theories that this new Constitution was a foreign import. It couldn't have been written by Virginians. It must have come from, I don't know, Beijing or Moscow or worse yet, from New York or Chicago, but it couldn't have been. And I just told you, all the people who were on the commission, plus the legislature, had all approved it. So, but we managed to get past that, and the new Constitution then went into effect. Well, that was 50 years ago. Some of the main accomplishments I could sum up very briefly, and they would include, very importantly, the reorganization of the education system, standards of quality. I'm sure you're aware of those, come into constitutional being for the first time in the 1971 Constitution. The Board of Education has primacy in educational policy. They're the ones who fashion standards of quality and the like. And then the General Assembly, of course, has the final word. They're the ones who come up with the budget. Very important in matters of race, there is for the first time in Virginia's history an anti-discrimination clause in the Constitution that says that the government shall not discriminate on the basis of race or color or the like, or interestingly enough, gender. Virginia refused to ratify the ERA, but it has a little ERA in its own constitution. So very progressive in that sense. And also remembering, again, the 60s, it was in the 60s that some Virginia localities had closed their schools. Some of you will remember the debacle in Prince Edward County where public schools were closed and a whole generation of students there were denied public education. The U.S. Supreme Court in 1964 handed down a decision requiring the county to reopen and fund public schools in the county. Well, the drafters of this Constitution in Virginia wanted to be sure that would never happen again. So you have two mandates. First is a mandate on the General Assembly to create a statewide system of public education for every child in Virginia. And then there's a second mandate on localities, which is to say that once the General Assembly decides on the financing apportionment, the formula for the state's share and the locality share, the locality, the county or city is constitutionally obliged to put up its share. And I read this section as saying the Attorney General of Virginia could mandamus a locality that refused. So you have very strong mandates in there that make it clear that we're not going to see another Prince Edward County kind of debacle in Virginia. So you have some very tight provisions. There are other areas. The court system is reorganized in a much more efficient way. There's an environmental article. This is brand new of 1971 that makes in the environment part of Virginia's public policy. The Constitution in general is shorter. It's about half the length of the old one. It's much better organized. It reads better. It's just in every way much more. It's not really a model constitution, but I think it's a very good one. I think it works very well for Virginia. Well, obviously, with the passage of time, everybody will think of questions that ought to be asked, issues that ought to be canvassed about how well the Constitution is working. For example, I'm sure you've all followed the debate over reapportionment of the legislature, that an amendment was agreed to by the people, setting up a bipartisan commission, half legislators, half citizens. I was a member of a drafting committee, an unofficial committee that proposed having a commission entirely of citizens. That would have been my first choice. The legislature went too far for the legislature. They decided on this bipartisan compromise, sort of half citizens, half legislators. That came to a deadlock. Many of you have followed that, I'm sure, and it finally fell to the Virginia Supreme Court to drop the final map. So one maybe ought to think about whether that needs to be tinkered with. There are other questions like the Dillon's rule. I'm sure you know that localities in Virginia, cities and counties, only have those powers specifically given to them by state law. I'm enough of a Jeffersonian that I think maybe we ought to revisit that, and maybe we ought to trust localities a bit more to do everything that's not forbidden by state law, to make the presumption in favor of local authority. There are other issues one might think about. One that interests me that we came to right up to the edge of changing, and that is the question of restoring the ballot to former felons who have served their time and they've paid the price and they're back in society again. Virginia is one of the strictest states in the country in disenfranchising former felons. They lose the right to vote permanently until and unless the governor restores their right to vote. Governor Terry McAuliffe, when he was in the State House, sought to restore the right to vote to about 205,000 former felons. The Supreme Court of Virginia slapped him down on that. They said, you have to restore rights one at a time. You can't do it to a class of people. With respect to the court, I think they were wrong about that. I think the Virginia Constitution gives the governor the power. restore right to a class of people, but say the court gets the final word on that. Professor Howard does not. I'm not a member of the bench. So, I mean, it's questions like that. I'm sure we can think of others. So, Bob, shall I pause at that point? And I'm hoping we have ample time for questions from folks who are tuning into the program today.
Absolutely, Professor Howard. Thank you so much for your time. If you're watching this, you can go to the Q&A portion of your Zoom screen and put some questions in there for Professor Howard. I've got a question. What do you think the possibility is of another constitutional convention in Virginia, say the next decade, and to discuss the issues that you had brought about, the Dillon Rule, restoring the vote to felons, that kind of thing?
Well, I have to be honest with you that aside from the fact that I was involved in the one that we presently have, I would be terrified if we had another convention. When in the 1960s, when Governor Godwin appointed his commission, they were truly the leading lights. They were the best minds in Virginia, and the way they worked, were bipartisan. Ted Dalton, who had been a Republican candidate for governor, was among the members, so it was a thoroughly nonpartisan kind of operation. I sat at the elbows of those commissioners as they worked, and I was stunningly pleased, really pleased at the way they worked together. They had a sense of the common good. If you had a convention today, of course, members of the convention would have to be elected. It would be a totally politicized thing. It would be reds and blues, liberals and conservatives, on and on. You would say, I think it'd be a mess. And you would get people from the extremes of both parties elected as members. Every single interest group, party person or group in the Commonwealth would want to be represented. And if they didn't get their particular provision in the Constitution, they would be against the whole thing. And that would apply whether it's guns or abortion or church and state. I mean, you pick the issue, but I think the Constitution would become a sort of a battleground for all those issues. So I think it would fall apart. I don't think they could frankly write a Constitution. If they did, I think it'd be a terrible one. So my sort of approach to that is, if there are faults, and of course there are, if there are things that ought to be fixed, that's what the amendment process is for. I think as state constitutions go, the one we've got has actually stood the test of time pretty well. As I mentioned a moment ago, it's not a model, it's not a perfect constitution, but it seems to me to settle in the mainstream of Virginia's aspirations and do a pretty good job. So if the proposition comes up, shall we have a convention? Count me in the no column.
Speaking of amendments, how do you think the Supreme Court did with redistricting the last couple of years? And how is that going to work itself out, you think?
They did pretty well.
Yeah.
I was not surprised. I know some of the justices. I don't know them all, but I mean, I respect them. I think they're diligent in doing what the Constitution requires. And I know there was some fear, especially in the editorial pages of some newspapers, that the court, being made up of mostly of Republican appointees or justices appointed by Republican majority legislatures, would draw a partisan map. And the process actually played out very fairly. They rejected appointees who would have been clearly partisan. They would not accept them as special masters. They finally had people who were objective. And among other things, you had a process that was thoroughly transparent, which is something we'd never had in Virginia. Redistricting had always been done in smoky rooms. So I don't agree with everything the Supreme Court does. I mentioned I disagree with them on their decision on restoring voting rights to felons, but on redistricting, I give them high marks.
I noticed something in the news the last couple of days. The governor has vetoed something like 24 bills, and he's amended something over 100. Can you talk a little bit about the governor's veto power and how that affects state government today?
Well, Virginia has an unusual process. I mean, obviously, in every state that I know anything about, the governor can veto bills. It's really very similar to the federal model where the governor vetoes a bill, it goes back to the legislature, they have to abide his veto or they can try to override it as the case may be. And so all that's true in Virginia. But in addition to that, the governor can send bills back with proposed amendments. And that's unusual among the states. And that by and large has been useful because sometimes bills get rushed through and maybe without sufficient attention to every detail of the bill. And then the governor's office, when the bill's on the governor's desk, may spot some flaw that ought to be fixed, but it's not the sort of thing that he thinks ought to result in a veto. So he can send it back and say, here's a problem with this bill, and then the legislature can accept that or not. By and large, most of those things are fairly small parts of a larger bill, and usually the legislature concurs with that. It actually enhances the governor's power. Virginia's governor, as governors go, the 50 governors, is probably one of the stronger governors in terms of appointments, in terms of we have the so-called short ballot in Virginia. We only elect 3 statewide officials, the governor, lieutenant governor, attorney general. We used to elect more people than that, the members of the State Corporation Commission, the Commissioner of Agriculture, and so forth. And in 1928, when Harry Byrd was governor, they accomplished the so-called short ballot. That makes government more efficient, but coincidentally also enhances the power of the governor, makes him sit atop of a much more focused administration. So now on the other hand, what circumscribes the governor, and this is something that perhaps is worthy of debate and discussion, which is we are the last state in the country, literally the last state where the governor can't run for re-election. So that means that he comes into office, he inherits his predecessor's budget. He's halfway through his 4 years when he can make up his own budget. And by then he's moving towards the end of his term. So that's debatable. I personally think that maybe we'd be better off if the governor could stand for a second term. I don't think I would have more than that, but if he's done a good job and people like it, maybe he ought to lay his record before the people. I think that would probably induce a bit more longevity. But I think the legislators don't want the governor to be more power. So I would be surprised if you saw an amendment agreed to by the legislature and put on the ballot, which gave the governor the right to run for re-election. There has been a fair amount of tinkering with this process of vetoes and legislative amendments and the like. And it's been a little bit of back and forthing between the governor and the legislature. Now we have an unusual sort of configuration that sometimes you have the same party in control of both branches, the governor and the legislature. At the moment, as you know, we have something of a hybrid where one party controls the Senate, the other party controls the House, and that makes things a little bit more dicey. And a governor who's never served in elective office, public office of any kind at any level. And it'd be fascinating to watch this as someone, I mean, I say I'm not in politics, so I'm a bystander, but it'd be interesting to see how a man who's been an executive of major business investment company, people who are executives tend to give orders and people just salute, and you don't get a whole lot of debate of whether that's a good idea or not. If you want to stay on board, you go along with it. I'm guessing that would be Governor Youngkin's sort of instinct to model, and the fact that he began his term on the very first day with an executive order dealing with, and I put it in quotation marks, so-called critical legal studies, which in fact is not taught in Virginia schools, but people call it that. But at any rate, on the first day of assuming office, he issues an executive order, which is not necessarily within his power. But he said, I want to do this, and here's what I'm going to do. But I've described the system of education, the Board of Education, the General Assembly, and the school boards at the local level all have constitutionally describe duties, the governor's not mentioned. So he doesn't have a place. I really am not sure he has the power to be saying, here's what will be or won't be taught in schools. We'll find out. I don't know if that's going to be litigated or not, but I mentioned that example just to suggest that it looks like we have a chief executive who's moving off with a very smart departure from the starting gate with the sort of mindset of an executive.
Yeah. Bob, I'll have a
Sue?
question when you're done.
I'm sorry?
I said, I'd love to ask a question when you're done with yours.
Please go ahead. Please,
Okay.
Sue.
And this might be a short answer, but I'm curious, Professor Howard, what does the Constitution say, if anything, about executive orders?
It really doesn't. And most of and this is debated at the federal level and throughout the country. Every state's had this issue come up in one form or another, especially during the pandemic. Because during the pandemic, there were just any number of executive orders requiring the wearing of masks or vaccinations of state employees or what happens or doesn't happen in schools and on and on and on. Every state has been the cockpit for debate and discussion of just how much power does a governor have. Now, in most states, including Virginia, there are statutes which prescribe circumstances when the governor can use his emergency power to issue a proclamation. And the more typical sort of arena is public health, something like a pandemic. But it also can happen if a hurricane blows through a Gulf state, for example, and destroys public communications and the like. That state probably will have on its book some sort of statute which tells the governor what he can do. So all those executive proclamations are within the bounds of some kind of conferred power. Now, what backs that up is an interesting question. The Article 5 of Virginia's Constitution is the one that deals with the executive. And it begins with a statement that the executive power shall be vested in a governor. And one can debate what it means to vest executive power. Does that imply that there might be emergency powers that a governor could exercise if there's no particular statutory authority? There usually is a statute that covers it, but in Virginia, we've had Governor Northam issued various executive orders, which I think were squarely based in statute. And some of those orders were challenged in circuit courts in Virginia. And to my knowledge, in every one of those cases, the order was upheld, the challenge to the order was rejected. I think there may have been one exception around Lynchburg, maybe Campbell County, I forget which court it was, but I think there may have been one court which accepted a challenge by, I think that maybe it was the owner of a gun range. I don't have the facts clearly in hand, but I think there was one order in which the court found that the governor's order couldn't apply to that particular factual situation. It was a very specific order for a specific kind of situation, not something of very general application. So laying that particular case aside, as far as I know, courts across the Commonwealth upheld various orders having to do with emergencies. Now, what we're verging on now, I mentioned that executive order handed down the first day of Governor Youngkin's term. What would happen if someone challenged that? That would not be, that's got nothing to do with the pandemic. It's a policy question of what should we teach our children and what should we not? That's a different arena of state government and therefore the Constitution. And the governor might point to some unenumerated sort of generalized power arising out of Article 5, but that would be, I think, a fairly new terrain. I guess what we may find out in time what the answer to that will be.
Thank you so much. And then now going back, when you were working on the Constitution in 1971, what were the issues you thought might not be settled, if you will, or might evolve or might continue to need attention?
That's interesting. Well, local government would be one. If I had to point to any of the articles of the Constitution, I think if I had to point to one which I thought left more unresolved questions, it probably would be local government. I mentioned Dillon's rule, for example. The commission proposed to the legislature that Dillon's rule be reversed, that you have a presumption of local authority. The legislature didn't like that, and they rejected that recommendation. They left Dillon's rule in place because I have a kind of a hunch. I can't prove this, but I think legislators enjoy keeping localities on a short string. The members of the city council or the board of supervisors have to go to Richmond hat in hand and ask for changes to be made. That empowers the local delegate or the local senator who can then introduce a bill. I think it's just like Congress, where you have markups on appropriation bills. I think there's a sense in the legislature that they sort of know better. I say, as a Jeffersonian, I would do it the other way around. But so there was an area where the proposal that the commission made was rejected by the legislature. There were obviously various adjustments made. There was one that I started to say it's humorous, but it's just unusual. And that is, there used to be a provision in the Virginia Constitution that said that churches could not be incorporated. It's an anti-clerical provision. It goes back to the founding era when people thought the Anglican Church, now the Episcopal Church, had too much power, and they didn't want to allow them to have a corporate charter, so they put that into the Constitution. Well, in my view, under the First Amendment to the federal Constitution, the Establishment Clause would certainly be used to strike down a state constitutional provision that won't let churches do what everybody else can do. I mean, churches are being singled out not to be allowed to have the advantages of corporate form of government. So I said to the commission, I said, that has to go because it would be invalid under the First Amendment. So the commissioners agreed. They took it out of the draft. But when it went to the legislature, there was I remember the delegate, Walter Fiddler, from down in Tidewater. I think he was from King and Queen County, a Baptist. The Baptist tradition is very strong separation of church and state. And he said, we don't want churches to be able to incorporate. Well, he carried the day. And so the legislature put that provision back in the draft Constitution. So it survived and it was in as of 1971. Well, then some of you may remember Jerry Falwell brought a suit in federal court challenging that provision. And it was an easy victory for him. I mean, the judge said, you're absolutely right. That provision is not constitutional. Well, so I could have saved the state of Virginia a lot of money if the legislature just left it the way the commission proposed. So, so I understand why they did it, but it was that was a mistake. So I'd say, going back to your question specifically, I think local government probably, you might ask the question, for example, do independent cities make sense? 100 years ago, you knew where the city ended because it ended where the streetcar line ended. And from that point on, it was countryside. Well, with suburban sprawl and the like, you go through Fairfax County or Henrico or Chesterfield or Albemarle County, and you have no idea where the boundaries are. They're totally arbitrary. So does it really make sense? I mean, I'm not a local government expert, but I think that's the kind of thing perhaps one ought to debate. Should we have independent cities and separate cities and counties? Certainly I would debate, as I've already pointed out, I would debate Dillon's rule. One also might wonder whether we should still have constitutional officers or not. The 5 officers that are in the Constitution, it would be simpler if they were in statutes, but I know the constitutional officers, they like being in the Constitution. And so this actually came up in the commission debates. I had gone up to Maryland, and Maryland they'd had a constitutional convention in 1968, and they wrote a really good constitution. They wrote a model constitution. And one thing they did was they took their constitutional officers out of the Constitution. Well, when they did that, they created a center of opposition to the proposed Constitution in every city and county in Maryland. The Constitution was voted down. Only two counties, Prince George's and Montgomery, approved the Constitution. It lost in Eastern Shore, Maryland counties by 8-1 majority. I mean, it was a total disaster. So I came back to Virginia and I told the commissioners, I said, the textbook approach would be to take those offices out and put them in the statute. But I said, that's a third rail. You do not want to touch that. And they agreed. They left them in. And then during the referendum campaign, we had the support of the 5 statewide associations. They all went on record as supporting the proposed Constitution. So I mentioned that as a story of how constitutions are not textbooks. They have to reflect and they have to live with the political realities of the world we're in. And so I thought the revisors of the present Constitution did a pretty good job of having an ear to that which ought to be done, that which could be done, and that which they ought to leave aside. That's one reason I think the Constitution has survived pretty well over these 50 years, because the people like Powell and Darden and the others, they knew a lot about what works and what doesn't work in Virginia. So any proposal one makes, however great it may sound on the face of it, one has to think a little bit about how people are going to feel about it.
Mm-hmm. Yeah. So how many constitutional amendments have there been in these almost 51 years?
I have not counted, but it seems to me every time I go to vote, there's at least one amendment. If you notice that, there's always one, sometimes 2 or 3. And usually they're kind of technical stuff. It's adjusting slightly whether you can give tax relief to widows of Army veterans, or those sorts of things that aren't a big deal in public policy circles. Sometimes they do address serious policy questions. You may remember a few years back when the Constitution was amended to define marriage, and that was clearly meant to make it impossible to have same-sex marriage. I thought that was a big mistake. I thought that ought to be left to political debate. Let people change views on that. We're evolving. And I mean, I can remember a time when very few people accepted the idea of same-sex marriage. And I think the vast majority of people today say, what's it to me if a same-sex marriage is not going to harm my marriage? It's, I shouldn't worry about that. We accept things we used to not accept. I thought it was a mistake I think in general, it's doubtful to load the Constitution up with social issues of a kind that ought to be left to the political process. So back to your question, there have been a lot of amendments. Most of them are fairly technical. Most of them pass. Most people just check them off, and occasionally they fail, but they're a nice safety valve because they do give people some ownership of the Constitution. Because, in law schools, you tend to think that judges do it all. And sometimes as ordinary people, we say, well, the judges do too much, but there is an important zone where people ought to have some interplay with the Constitution. And as I suggested a moment ago, I would not myself favor a constitutional convention, but I think having an amendment process which is not too difficult is healthy. Contrast it, if you will, with the federal Constitution. We've had 27 amendments to the federal Constitution in almost 3 centuries, and the first 10 of those were the Bill of Rights. They were done at the very beginning. So it is enormously hard, almost impossible to amend the federal Constitution. Ask the proponents of ERA, who thought they had it nailed back in the 1970s and it failed. And now, as you perhaps know, they're trying to revive that and say that Virginia, for example, agreed to it. But the conventional wisdom is that unless all those state votes were within the same period of time originally set up by Congress, that they don't count. That's still being debated. But at any rate, it's so difficult to amend the federal Constitution. And we have, in addition to that, a dysfunctional Congress, a political system in Washington where nothing seems to get done. The people at arm's length with each other all the time. It means that state governments and state constitutions are where so much of the action is. And I read the U.S. Supreme Court, for example, the Supreme Court in Washington has held that reapportionment cases can't be brought in federal courts, that they are a political question. You can't raise a federal challenge to a reapportionment scheme. So the only challenge you can bring is in a state court. You depend entirely on the state constitution. That's terribly important. And I think we're going to see more and more areas where as the Supreme Court becomes more conservative, I think the 6-3 majority is going to start moving in a more conservative direction. It's going to place more emphasis on what the states do, and therefore in state constitutions. So to have state constitutions, which by contrast to the federal model are more readily revised or amended or the like, I really think brings people, the ordinary people, into play in a way the federal model does not.
Thank you so much. And I have one more question, Bob, if I'm allowed.
Oh, absolutely.
Okay. If you were asked about an amendment that needed to be considered to the Constitution, what would you say?
Which amendment?
Any amendment.
Oh,
In other
any
words,
amendment to the federal or Virginia Constitution?
Virginia.
The Virginia Constitution. Well, yes. Okay. There are some I would reverse Dillon's rule. I would say that it does not apply in Virginia. I would make it easier for former felons to vote. There was an amendment which had been approved in a session of the General Assembly, but in Virginia, proposed amendments have to be approved twice by the legislature with an intervening election of the House of Delegates. And so the first time it got through, but then with the change in the House of Delegates, it failed. And there was a hearing down there, and it's interesting that conservatives and liberals, everybody who showed up at that hearing favored the amendment, including people on the right, as well as people on the left. And even so, the committee refused to let it out of committee to go on the floor. So it looks like, so that's not going to be on the ballot. We were that close to changing to readmitting to the franchise former felons. So that one I feel strongly about, and I don't know what it will take to get. When I have to start all over again, I guess. So I would do that. I would probably favor a second term for the governor. I would like to hear debate on that. There may be, when I think about the governors we have had over the past few decades, without naming names, maybe having a one-term rule was not a bad idea after all, but that's a thoroughly unprincipled position for me to take. So, but I would probably let the governor run for re-election. Are there other? I would certainly revisit the reapportionment, since the commission that was put in place collapsed and couldn't work. It may not be easy to find one that would work, but I certainly want to take a close look at that. So I think we ought to have an ongoing statewide seminar using the Constitution of Virginia as a way of thinking about policy issues, precisely because it's not like a law that you can just pass and have the governor sign, but it's harder to change it. It makes people think more about it. So I like your question, because I think ordinary citizens ought to be asking themselves the question, what is there about? First place, they ought to read the thing. It's not that long. It's pretty plain language, it's pretty straightforward, it's well organized. They ought to dip into it, read some provisions of it, see what they think, and see whether an amendment is called for.
Thank you. All yours, Bob.
All right, Professor Howard, we just want to thank you for your time today, for taking some time away from your busy class schedule. If you've been watching Zoom for the last hour, we've been listening to Professor A.E. Dick Howard. He's the Warner Booker Distinguished Professor of International Law at UVA, former Supreme Court clerk, Rhodes Scholar, and an expert on the Virginia Constitution. Dr. Howard, once again, thank you so much. Professor Howard, thank you so much for your time. And I'm going to throw it back to Sue Friedman.
My pleasure. Thank you very much.
I also want to say thank you. I may call you up and invite you out for coffee. This is fascinating to me as a political science major. So thank you so much for joining us today. When we post the recording on our website, we will also try to post a link to the Constitution. So all of you who are listening and when you share the recorded program with others can readily get to that Constitution and read it, as Professor Howard suggests. So thank you again, Professor Howard. Thank you, Bob Beard. Thank you, as always, to Grant Brownrigg and Jim Peterson for the technology and registration backup. Thank you to Barney Brewer for the publicity for this activity. And thank you to all the remaining board members for always coming up with very stimulating programming for Senior Citizen of Virginia. And if you're not yet a member of Senior Citizen of Virginia, my one question is, why not? It's $20 to join for an entire calendar year, and it includes your household, including your four-footed friends and family members. So please visit Senior Statesman of Virginia, join us, and read your Constitution. Thank you very much, and have a great rest of this beautiful spring day. Thank you.